Good day, ma'am. My name is Radney Blajambi Scream 4C, and this is my video about the Rule 130, the Object Real Evidence in Section 1. Object as evidence are those addressed to the senses of the court when an object is relevant to the fact and issue. It may be exhibited to, examined, or viewed by the court. For example, anything can be seen in the crime scene as evidence. Object evidence addressed to the sense of court. Anything can be an object evidence as long as it can be seen, smelled, heard, felt, or tasted, and that it's also offered to be seen.
Rule 130, documentary evidence. So, Section 2, documentary evidence. Documents as the evidence consist of writings, recordings, photographs, or any materials containing letters, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of written expression offered as proof of their contents. Photographs include still pictures, drawings, stored images, X-ray films, motion pictures, or videos. So those are the documentary evidence. For example, a dispute between ABCD Corporation and XYZ Entertainment Corporation. So ABCD Corporation is claiming that XYZ Entertainment Corporation has not yet paid its obligation of 11,000 pesos. So ABCD Corporation filed a collection a case against XYZ Entertainment Corporation. So now XYZ Entertainment Corporation has a defense is the claims that it has already paid the 11,000 pesos. So what will be the defense or what will be the evidence of XYZ Entertainment Corporation? In order to prove that it has already paid the 11,000 pesos, the XYZ Entertainment Corporation will present the official receipt saying that it has already paid amounting of 11,000 pesos to ABCD Corporation. For example, XYZ Entertainment Corporation will present this official receipt, but we must remember that the fact that the evidence presented in court is a document does not necessarily mean that it is documentary evidence. It will now depends on the purpose of the documentary evidence. So the purpose in order to be considered a documentary evidence, it must be offered as proof of its content. So we'll go back to the example. So as you can see, that the content of the official receipt is saying received from XYZ Entertainment Corporation in the sum of 11,000 pesos. That is the content of the official receipt. So the defense of XYZ Entertainment Corporation that it has already paid 11,000 pesos to ABCD Corporation. So this official receipt is offered as evidence, offered as proof that XYZ Entertainment Corporation has already paid the sum of 11,000 pesos. So this is trying to prove what is in the content that XYZ Entertainment Corporation has already paid the 11,000 pesos. So the content is already proof that it is a document.
Good day, ma'am. I am Frederick Binasbas of BS Crime 4C, and I will recite and explain the Section 3 of Rule 130. Section 3 of Rule 130. Original document must be produced. Exceptions. When the subject of inquiry is the contents of a document, no evidence shall be admissible other than the original itself, except in the following cases. A. When the original has been lost or destroyed or cannot be produced in court without bad faith on the part of the offerer. B. When the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice. C. When the original consists of numerous accounts or other documents which cannot be examined in court without the great loss of time, and the fact sought to be established from them is only the original general result of the whole. And D. When the original is a public record in the custody of public officer or is recorded in a public office. So When we say no evidence shall be admissible other than the original itself, it means that the original document or evidence is the only valid or acceptable one. But there are circumstances that we cannot avoid, that the original one can be destroyed or lost, or maybe it is in the custody. So there are exemptions. For example, the evidence is a written document. You can present a copy of the document when the original is not available, especially when it is lost or destroyed. So when the original is under the custody or the control of the party against whom the evidence is offered, so you can produce or you can give or present the copy when the party fails to produce it after reasonable notice. So when you say the original consists of numerous accounts and other documents, you can also provide some copies to present in court. So, and if it is a public record, you can also produce a copy of it. And it is stated that there is exemptions when it comes to presenting a original document.
Good day, ma'am. I am Ernst Macara from B Screen 4C, reciting the rules of evidence. Rule 130, Section 4, Original of Document. The original of the document is one the contents of which are the subject of inquiry. When a document is in two or more copies executed at or about the same time with identical contents, all such copies are regarded as originals. When an entry is repeated in the regular course of business, one being copied from another at or near the time of transaction, all the entries are likewise equally regarded as originals. For example, in making a contract, once you are creating a contract, you are also making a document, because in making a contract, it has transactions and important informations in content. It is a subject of inquiry because it can give you important informations that you are looking for. As the meaning of document, which is the official piece of paper that contain important information that can be used as a proof. When a document is in more copies executed at or about the same time, it still has authenticity if being created by hand or typewritten, unless it is being photocopied. So if a document is repeated in a course of business, being copied near the time of transaction, it is still authentic if not photocopied.
Good day, ma'am. Rule 130, Section 5. When original document is unavailable. When the original document has been lost or destroyed or cannot be produced in court, the offeror, upon proof of its execution or existence and the cause of its unavailability without bad faith on his part, may prove its contents by a copy or by a recital of its contents in some authentic document, or by the testimony of witnesses in the order stated. Example: certified copies of the original document, copies made out of the original documents using a mechanical process, copies created from or compared with the original documents, duplicates of the documents against the parties not executing it, oral description of the document's contents.
Good day, ma'am. This is Constantino Emery of BS Screen 4C. This is memorization in Rule 130, Section 6. When original document is in adverse party, custody, or control. If the document is in custody or under the control of the adverse party, he must have reasonable notice to produce it. If after such notice and after satisfactory proof of its existence, he fails to produce the document, secondary evidence may be represented in the case of loss. For example, if you lose one of your legitimate ID and needed to replace it with a new one, you must comply with the requirement before they will provide you new one or your valid ID. For example, maybe they require you to provide an affidavit of loss you must comply since it was dated. You must provide proper evidence for them to provide for a new legitimate ID. So it's like being inside the court. If you don't have original evidence, you must give secondary evidence before providing the evidence.
Rule 130, Section 7. Evidence admissible when original document is a public record. When the original of a document is in custody of a public officer or recorded in a public office, its contents may be proved by a certified copy issued by the public officer in custody thereof. Thank you.
Good day, ma'am. My name is James E. Estares from Scream 4C. Today I will memorize and give example of Section 8 of Rule 130. Um, Party who calls for document not bound to offer it. A party who calls for the production of a document and spec the same is not obliged to offer it as evidence, meaning they have no obligation to offer the document as an evidence. For example, the party asks for production and inspection of a and document, but they have no but they cannot produce it or offer it as evidence because they have no obligation or they are not obliged. Thank you, ma'am.
And this is the section 9. The evidence admissible when original document is a public record. When the original document is in the custody of a public officer or is recorded in a public office, its contents may be proved by a certificate copy issued by the public officer in custody thereof. The following is a parole evidence rule. Example: say an engaged couple hires a wedding photographer and draws up a contract. The photographer agrees to attend the wedding for 8 hours and charging 4,000. All parties signed the contract days before the wedding. The photographer calls the couple and indicates what something has come up and they will only be able to take photos for 4 hours.
Section 10 of Rule 130, Interpretation of Writing According to its Illegal Meaning. The language of writing is to be interpreted according to the legal meaning it bears in the place of its execution unless the parties intended otherwise. Uh, the language of writing should be interpreted according to its illegal meaning, especially the place where it is executed. It is important to interpret it to its illegal meaning in order to know its meaning for some party that didn't know if the words exist. For example, when the evidence is written in English, but the place in on Manila, they need to interpret it in its illegal meaning, especially the language is Tagalog. Thank you, ma'am.
130, Section 11. Interpretation of a writing according to its legal meaning. The language of a writing is to be interpreted according to the legal meaning it bears in the place of its execution, unless the parties intended otherwise.
Good day, ma'am. Rule 130, Section 12. Interpretation according to intention, general and particular provisions. In the construction of an instrument, the intention of the parties is to be pursued, and when a general and a particular provisions are inconsistent, the latter is paramount to the former. So, a particular intent will control a general one that is inconsistent with it. For example, if the terms of the contract are clear and leave no doubt upon the intention of the contracting parties, the literal meaning of its stipulations shall control. If the words appear contrary to the evident intention of the parties, intention prevails over words. Thank you.
Section 13. Interpretation according to circumstances. For the proper construction of an instrument, the circumstances under which it is made, including the situation of the subject thereof and of the parties to it, may be shown so that the judge may be placed in the position of those whose language he is to interpret.